Hi, I'm Shane from Shanesmithlaw. Today I'm sitting here talking with one of the attorneys, John Wheatley, from our office, and I'm going to talk about one of his recently settled cases. Tell us about the case we're talking about today, John.
Okay, so today we're going to talk about our client. We'll refer to him as MM. He's 46 years old. He worked in construction and roofing. The defendant pulled out in front of him while he was driving down the road. He had the right of way and did not have time to avoid a collision because the defendant pulled right in front of him. The client ended up with neck and back injuries. MRIs revealed bulges in his cervical spine and a herniation in his lumbar spine and his disc. The cervical spine was actually healed through conservative measures and some injections, but the lumbar spine was a bit more problematic, and an orthopedic surgeon believed he needed to obtain a minor lumbar surgery in order to heal his injuries. The insurance company didn't dispute liability at first, but they did present a very low offer initially for settlement. It was around $8,000, and our client had a good amount of bills and a surgery that he needed to obtain. So they used that he had prior injuries as their method of providing a low result or a low offer for settlement. But it turned out that those prior records that we sent in ultimately hurt their argument when they tried to bring it up, because they tried to say that in 2018, when we sent in his ER records from a fall that he had from a ladder, that he had continued hurting from that. But the problem is that 2 days later, he went back to the ER in 2018, and it said that all his back pain had been resolved. So the very records that they were using to downplay our claim were actually helpful to us in the long run.
All right.
Yep, go ahead.
I was going to say, so the base of their argument was it he hurt himself before and then everything was degenerative in the neck and back?
Yeah, they were essentially saying that because he had hurt himself in 2018, that his injuries weren't caused by the accident. And to that point, the damage to the car wasn't very severe. So they were essentially saying that the collision couldn't have caused his injuries. But when we used his medical records, both prior and existing, there was no doubt that all of his injuries that he was treating for were caused by the accident.
Great. And I know the initial offer was what we would consider to be very, very low in light of the treatment he had to receive. How did the case end up?
We ended up obtaining the policy limits there for about $100,000. So it went from a very low offer to the most amount that we could possibly settle for against the insurance company.
Great. How long did that whole fight take with the insurance company after they came in with that low offer to get it up to that policy limits offer?
It took probably a little over a month to going back and forth and almost letting them realize that, you know, what their argument was stating was hurting them more than it was helping them, and they didn't really have much of an argument at all. But once we got that, and I really drilled down in those prior medical records that his injury 3 years prior had completely healed in 2 days, there wasn't much they could do after that, and they offered the policy limits.
Great. I mean, it sounds like a wonderful result for the client. It sounded like the key here really was finding out what they were basing the whole argument on, and then just basically cutting their legs out from under them.
Yeah.
And feuding it. Okay. Sounds like a great job there. Is there anything that you would say you specifically learned in this case you're going to be able to use to help your clients later on?
Yeah, I would say that attention to detail is pretty significant in terms of what you can find in the medical records, and that not necessarily having an injury prior to the collision is going to be detrimental, because in this case, those records actually reinforced exactly what we were saying. So bringing up prior medical records and having a prior injury is not always detrimental, and sometimes it can be very helpful.
No, I would agree. I think sometimes it's just as long as you're clear with the attorney and tell you about them, you can prepare and look at them and investigate and do what you need to do to either, you know, say they don't relate to the accident, like in this case, or even to say, well, maybe it did something, but it contributed, but it's not an end-all be-all to the results. So then great job, John. Thanks for talking to everybody about this case. Sounds like a wonderful result for you and your client.
Yep. Thanks again, Shane.
All right, thanks. Bye.
Bye.
Thanks for listening to today's call. Remember, if you're in pain, call Shane, 980-999-9999, or you can order our free book, Victim Survival Guide to Car Accidents, at www.shanesmithlaw.com. We'll be going over another case next week and hope something we can learn from that, and hope to see you there.
980-999-9999. 980-999-9999. Shanesmithlaw. In pain, call Shane.